Okay, so good morning everyone. So today's meeting is to discuss the content of the partnership agreement between the partners, which serves as the foundation governing our business relationship. In particular, we will focus on several key areas, including the profit sharing arrangement, the management structures of the partnership, the duties and responsibility of each partner, as well as issues relating to indemnity and liability. These provisions are crucial to ensure clarity, accountability, and risk management within the partnership. As we conclude the discussion, we will also reflect on the challenges encountered during the drafting of this agreement, and the lessons learned throughout the process, which are valuable in strengthening mutual understanding and ensuring a more sustainable and effective partnership moving forward. So, may I ask Mr. Hanif to explain more on his part?
So thank you to our managing partner, Mr. Danish. So good morning to all partners and associates of the firm. My name is Wan Muhammad Hanif, a senior partner of the firm. As per the agreement that we have all read and reviewed, I believe we are aligned on our general vision for the firm. However, before we move forward, I would like to touch more on one specific part of clause 6, specifically the concluding section regarding our financial framework. While the earlier sub-clauses handle our day-to-day accounting, this final paragraph is the most vital. It acts as the legal anchor for our profit sharing and protect the individual capital each of us is committing today. The primary purpose of this section is to ensure our partnership is governed by our specific rules, not a one-size-fits-all legal defaults. Under Section 26 of the Partnership Act 1961, the law assumes that unless there is a written agreement saying otherwise, all partners are entitled to equal shares of profits and must bear losses equally. Since our capital contribution and rules are not the same as we have detailed in Schedule 1, following the equal share rules will not be fair or accurate to our actual investment. Therefore, we have drafted this clause to explicitly displace the Act, allowing us to legally prioritize the specific percentage we have agreed upon. The legal significance of the phrase notwithstanding any contrary is that it creates a priority shield. It tells any court or auditor that Schedule 1 is the final authority regardless of what the general law says. We draft it in this way to ensure two things. The first one, which is capital protection. It guarantees that your initial investment is credited solely to your own capital account. The second one, proportional risk. It aligns our share of the profit with our share of the losses. This ensures that financial rewards remain perfectly balanced with the risk each of us has agreed to carry. This part of clause 6 is what makes our financial arrangement legally bulletproof. It transforms our internal agreement into a binding structure that respects the unique value and capital each of us bring to the table. It also provides us with the financial certainty needed to operate with full confidence, knowing our interests are secure exactly as we intended. Having addressed this critical point, I am confident that we are now ready to proceed with the final execution of the agreement. Thank you.
Okay, thank you, Mr. Hanif, for such a wonderful insight. Okay, now may I ask Mrs. Hana to explain more on the management and duties of partners part?
Hi, good morning. Thank you to Mr. Danish as our managing partners. My name is Siti Rashidatul Hasina binti Husni, and I'm also one of the partners of the firm. So I'll briefly walk us through Clause 7 and Clause 9 of our partnership agreement, which deal with authority, representation, and decision making within the firm. So let me start with Clause 7, which sets out the legal authority of each partner. Under Clause 7.1, every partner is recognized as an agent of the partnership and of the other partners. This reflects Section 26, Clause A of Partnership Act 1961. What this means in practice is that any act carried out by a partner in the usual course of the firm's business will bind the entire partnership. So, if a partner enters into a routine transaction or makes a decision that falls within our normal business operations, the firm is legally responsible for that act unless the partner had no authority and the third party knew that the partner lacked that authority. Why this clause is important is because it allows the firm to operate efficiently and give third parties confidence when dealing with any one of us. However, Clause 7.2 introduces an important safeguard. It clearly states that no partner may use the firm's name, property, or credit for personal purposes without the consent of other partners. So, this protects the partnership from misuse of assets, personal liabilities being passed onto the firm, and reputational risk. So in short, Clause 7 balances trust and accountability. So we each have authority to act for the firm, but that authority must always be exercised for partnership purposes, not personal ones. So let's move on to Clause 9. This clause explains how decisions are made within the partnership. Okay, under Clause 9.1, all matters arising in the ordinary course of the partnership's business are decided by a majority of the partners, in line with Section 26, Clause E of the Partnership Act 1961. So this ensures that day-to-day operations are not delayed and the firm can function efficiently without requiring anonymous consent for routine matters. So, for example, of ordinary business decisions may include, which is operational arrangements, routine contracts, or internal management matters. At the same time, this clause works together with other provisions in the agreement, particularly those requiring anonymous consent for matters outside the ordinary course of business, such as major contracts, borrowing, or disposal of assets. So, essentially, Clause 9 promotes efficiency while preserving collective control over major decision. So I think I've explained all.
Thank you, Miss Hannah, for the wonderful explanation. I totally agree with Miss Hannah that management and the duties of partners clause in this agreement is really important for our firm. So now, if possible, may I ask Miss Huda to explain more on the indemnity and liability part?
My name is Huda Izzati, one of junior partners. For Clause 16, this clause focuses on indemnity and liability among the partners. The purpose of this clause is to clearly determine who is responsible when any loss, damage, or liability arise during the partnership business. It helps protect both the partnership and individual partners by setting clear boundaries of responsibility. In terms of legal significance, Clause 16 ensures accountability. If a partner causes loss through negligence, fraud, or breach of the agreement, that partner must be indemnify the partnership and the other partners. At the same time, the clause protects partners who act properly in the ordinary course of business by allowing indemnity for liabilities incurred lawfully. This creates a fair balance between responsibility and protection. This clause also aligns with the Partnership Act 1961, particularly Section 11, which provides that the partners are jointly and severally liable for partnership debts. Clause 16 reflects this position and further clarifies that liability continues even after a partner exits the partnership. Lastly, this clause was drafted in this manner to ensure fairness, risk control, and certainty. It prevents innocent partners from bearing losses caused by another partner misconduct while still complying with the statutory position under partnership law. So that concludes section 16 and for indemnity.
Thank you, Ms. Huda, for the clear and comprehensive explanation on the indemnity and liability clauses. Your breakdown really helps us understand how these clauses protect the partners and ensure accountability within the agreement. So we have done with the clauses part. May I ask Ms. Safa to give us the group reflection throughout the creation of this agreement?
I think before we conclude, I am Safa Amelia. As a senior associate for this firm, I think I would like to briefly highlight the main challenges we face in drafting this partnership agreements for our firm. So I will address one key challenge was aligning the default provisions of the Partnership Act 1961 with the specific needs of our firm. So while the Act provides clear statutory rules, particularly on management and dissolutions, we had to decide which provisions to retain and which to expressly modify through agreement without undermining the legal framework. That's the one thing. And another challenge was drafting the dissolutions and winding up provisions, especially where court intervention may be required in this matter. And I think it was important to clearly distinguish between contractual dissolution and dissolution by court under Partnership Act 1961, which while we ensuring the language remain precise and suitable for an agreement rather than just a statute section. So we also had to realistically anticipate potential dispute among partners and incorporate dispute resolution mechanism that encourage internal resolutions before legal action. So in order to preserve professional relationship between partners and business continuations. So I think overall the drafting process created by my department required careful and legal judgment to ensure clarity, enforceability and compliance with the Partnership Act 1961. So with that, I will pass the floor to any other arising matters any other arising matters.
Thank you, Ms. Safa, for explaining the challenges so clearly. Your breakdown really helps us to understand the key issues we faced and how they impacted the overall process. So now, if you don't mind, Ms. Alia, could you explain to us the lesson learned regarding partnership law and teamwork throughout the partnership agreement that we've made?
Thank you, Mr. Danish. My name is Alia Hayani binti Abbas. I am one of the senior associates of this firm. So, moving on to the reflection, there are several important lessons we learned from this drafting. First, we learned that having a written partnership agreement is crucial. Although the Partnership Act 1961 do provides default rules, those rules may not suit every partnership. A properly drafted agreement allows partners to tailor their legal relationship to their needs. Second, we learned that partnership involve unlimited liability, meaning all partners are jointly and severally liable for the debts of the firm, regardless of their profit share. And then, the capital contribution does not automatically determine control or management power. Even though partners contributed different amounts, management rights remain equal, reinforcing the principle of equality among partners unless otherwise agreed. In terms of teamwork, this project taught us the importance of clear role allocation and communication. Assigning specific clauses to different members allowed us to work more efficiently and responsibly. We also learned that effective communication and compromise are essential, especially when discussing sensitive issues such as capital and profit sharing. In conclusion, this drafting exercise enhanced our understanding of partnership law while also strengthening our teamwork and collaborative skills. That's all from me. Thank you.
Thank you, Ms. Alia, for a really thoughtful insight. So before we end our meeting today, may I ask Ms. Khatijah to give us the recommendations on how we can improve our agreement and also the conclusion to conclude our meeting today?
My name is Dr. Khatijah bin Roslan. I'm the senior associate. So I will explain about the future improvement. Going forward, there are a few ways we can further improve how the partnership is managed. First, we can review the partnership agreement regularly to ensure it meets the business need and current law. Second, we can improve into the process, such as how the partner join, leave, or handle dispute, so that everything is clear and organized. The regular guardians for partner will help everyone better understand their role and responsibility. Finally, we can introduce stronger risk management measures to protect the partnership and reduce potential problems in the future. In conclusion, today's discussion has provided us with a clearer, more organized framework for managing the partnership. So this improvement will support fairness, stability, and smoother operation for all partners. With this, we can now conclude our session confident that the partnership is well prepared for future. That's all from me. Thank you.
Thank you, Ms. Khatijah. So I guess that's the end of our meeting. We will be having another meeting for a future discussion. Thank you.